Good evening, everybody. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York, and today we're going to be having our legally speaking on effect of probation for immigration purposes. I will start this broadcast, and my colleague Anthony Calalori will continue regarding criminal portion of the presentation, and I will start with immigration. Basically, probation is one of the forms of sentencing after the person gets sentenced and gets convicted. Usually, the proceedings of sentencing or conviction, they have the two parts. The first one is when the person pleads guilty or is found guilty, and the second one is the conviction itself. And conviction is may take different forms. It can be a fine, it can be time in jail, and one of the form of convictions is a probation, or sentencing, I'm sorry, is a probation, one of the punishments. As a rule, probation is still a punishment and it is a conviction, but for certain exceptions to the immigration consequences, probation sometimes is much better than jail time itself. For example, if we talk about good moral character necessary for citizenship, the conviction in the form of, or sentencing in the form of probation will be better than, let's say, conviction in terms of imprisonment. Probation for 3 years or 5 years will be better than imprisonment for
Alena, take the video on. Put the video on.
For lesser time, because probation itself is not something that will disqualify a person from a good moral character, finding of a good moral character. However, the citizenship or naturalization application will not be granted until the person is on probation, but it will not be by itself a disqualifier. Why the citizenship application will not be granted until the person is on probation? It is because if the person is found in violation of probation, he or she will will be subjected to additional punishment, and as a result might not be found to be a person of good moral character. That's why the immigration, as a rule, will wait and see what's going on with the probation. For criminals, I'm not sure if Anthony joined us. I don't think so. He hasn't yet. But for what I wanted him to talk about today is the criminal portion of the probation. It's basically what happens and how to deal with violation of probation. Because violation of probation, if I'm not mistaken, under New York penal law can be punishable as a misdemeanor, and may present a serious problem. First of all, it's an additional conviction that will probably disqualify a person from finding of good moral character. Very often, violation of probation causes imposition of a sentencing in the form of jail time, which is for sure will be a problem. What to do if the person has options, either to be subjected to jail time or receive a probation, if the person can negotiate these terms? Well, in each specific case, this should be resolved in consultation with an immigration attorney, because, as I said, different it depends, first of all, on the person's status and what that person would like to do in the future. Does this person would like to keep their status if they're green card holders? Would they want to apply for, and if they qualify to apply for naturalization? Maybe that person does not have any status. So the next step and how to negotiate the plea will depend on those factors. If the person, let's say, would like to apply for naturalization, a single offense usually that qualifies as a petty offense for immigration purposes, if there is, if the sentence imposed is not a prolonged jail time, will not disqualify a person from naturalization. And probation in this situation, even if probation for 2 or 3 years, will not disqualify a person from naturalization, but it will prevent the person from getting it until the person completes the term. So in this particular situation, let's say a person has in mind, person plans on applying for naturalization, then the person probably is better off accepting a short jail term or a longer probation. What if somebody does not have any status at all? Well, in this situation, it's probably not going to matter much, because the person still will have to resolve whether or not he or she will be inadmissible or inadmissible for the purposes of adjustment of status, if they have that in mind. And the conviction itself, that would matter more than the sentence. So the criminal defense attorney will have to then work with the immigration attorney to see how they can lessen the impact of that conviction. Can a person plead to something less serious instead of a misdemeanor to maybe disorderly conduct, even though disorderly conduct under New York penal law is still a misdemeanor according to federal law, so it's still a conviction. The only thing that will not have effect for immigration law is going to be ACD in New York, or straight dismissal, or violation. Everything else pretty much will have immigration consequences, or might have immigration consequences. The harshest and most difficult consequences come from a conviction which is recognized under immigration law to be an aggravated felony. And unfortunately, that aggravated felony can be found if the person is convicted to a probation, but it's a conviction of a certain offense. So in this situation, if the statute under which the person is convicted is of a certain description, it would not matter whether the punishment is conviction or if it's a probation. A very important point about probation and probation reports, which we had and we touched upon in our early seminars, is there is such a thing as a probation report. When the probation office prepares a report for the purposes of sentencing describing their view of what the person committed. One of the crimes that qualifies as an aggravated felony is when a person commits a crime of moral turpitude, punishable up to, crime of moral turpitude, of fraud or deceit, with $10,000 and more in damages. Sometimes that $10,000 and more are not in a conviction, in a record of conviction, in a strict record of conviction, which we would consider classic, conservatively a record of conviction. But that number can be somewhere in a probation report. And in this situation, it would be probably necessary for a criminal defense attorney, if possible, to challenge that finding in the probation report. So probation and that probation report can greatly affect a person's chances of any future in the United States if the crimes that they might be convicted or being convicted of is an aggravated felony. There are a couple of recent important decisions by the U.S. Supreme Court that specify how a crime should be analyzed, and specifically crime involves controlled substance should be analyzed in connection or in comparison between state statutes and federal statutes and the consequences of those. So what I'm getting at is that this is a rather complex area. Whenever we're dealing with immigration consequences of criminal conduct, a person should work with a very knowledgeable, experienced immigration attorney, in addition to a criminal defense attorney, who would want to spend time to educate him or herself, to do some research, because no matter how much and what you know, the law in this area is constantly changing. The court relies on different courts. They rely sometimes on different approaches, how they look at the crime, whether or not they would allow different documents into the case, into immigration case, based on how they look and analyze the crime. And it's very important sometimes to educate criminal defense attorney what he or she has to do during the criminal proceedings, so that it will help an immigration lawyer in immigration proceedings. So the bottom line, that probation might not be the worst thing in the world when the person in connection with the immigration cases, that the criminal defense attorney should always consult with an immigration attorney as to the findings contained in the probation report. Also, that the probation itself, the person should be abiding and following the rules of probation, because if those rules are violated, the consequences will be harder than the original punishment very often. I will accept questions about this topic via my website, www.shautsova.com. You can always find me by dialing 917-885-2261. So you're welcome to email your questions and submit them over the phone. Remember, whenever you have or you're charged with criminal charges, you always should consult with the criminal defense attorney first, because that's very, very serious and very important for both criminal and immigration cases. Thank you very much for joining us today, and I'm looking forward to your questions.